Project delays, redevelopment issues, society problems, or transfer of property. If you have any legal query related to property, you've tuned in to the right show. Hello and welcome to Magicbricks Now. You are watching Property Hotline. I'm Kavita Krishnan, and today our show is going to only answer all your legal queries related to real estate. Like I just told you, our special guest is Uday Wavikar. Uday is the VP of the Consumer Court Bar Association, Maharashtra and Goa, and he has been fighting for home owner and home buyer rights for a long time. Uday, welcome to the show. Let's start with a question that's coming on our website, www.mbnow.in. Gaurav writes in, says that he wants to know when a developer can be sued for providing an alternate property if the builder fails to deliver on the booked property. So apparently in his builder-buyer agreement, there is a clause which mentions this. Now the property in question is Unitech Vistas in Gurgaon. Additionally, he wants to know if a buyer can file a case to stop paying home loan EMI till the time there is clarity on construction of the project. He adds that there was a tripartite agreement that was signed between the bank, the buyer and the builder. You know that this is a question that buyers are increasingly posing to us nowadays, especially the bit about the EMI, because the fact is if the project gets delayed, if the developer stops construction, the bank is not going to stop taking your EMI. Your EMI the meter continues ticking, you continue paying your EMIs, but the project is delayed. What does a buyer do? Is he within his rights to stop paying EMIs?
Kavita, in this, if you see, there is a tri-party agreement between the bank, buyer and the builder. That is the last thing of his question. So, if the agreement provides for that, then surely he can stop the EMIs. But otherwise, he cannot stop the EMIs because there is no direct, it's not development link EMI. You are taking a loan for your house. It is given at a particular rate. Banker would definitely ask you the money even if it is not developed. What you can really do is you can definitely go to the consumer court, ask for an interim relief and get an relief perhaps if the court gives you as an interim relief. But if the agreement provides, there is no question.
Now let us, I have, before you move on to the next part of the question. Now you said it's not a development linked EMI, but the fact of the matter is a lot of us buy under construction homes and we buy it, the loan that, it is bought on construction linked payments. That's the plan that you buy it on. So if the construction is stopped, can I ask my bank to stop payments to the developer?
Exactly, I am therefore on an agreement. In this case, there is a tri-party agreement. You must ensure that in your agreement itself, there must be a clause that in case the development is delayed, the steps of development is delayed, steps of payments are delayed, I can stop my EMI to such a time when the construction restarts. Unless there is a specific understanding on the development link plan, then otherwise the bank will insist on this thing.
Which of course no bank and no builder is ever going to give you in an agreement.
No. Here there is a tri-party agreement, no. So if the tri-party agreement says that you have to pay, remember one thing under MOFA also, you have to pay 10% at the initial slab, then 15% for another slab. So payments are defined by standard Schedule 5 agreement of Maharashtra Flat Ownership Act. What I am saying is a standard agreement provides, or any agreement for that matter, provides payment development linked. Now if the payments are not going from the bank, we must ensure in that agreement or tell the bank, no, I cannot pay because your plan is also development link. And then only they can get the relief. Unless otherwise there is an agreement, I'm sorry, but the bank is not going to leave you for your EMIs and they might take an action. Now question is, if your flat is hypothecated with the bank, the action naturally will be on that, and then you will have to pay little extra interest or penal interest. So that is there. Therefore, we have to come out with a clear-cut understanding with the bank before taking the EMIs, because generally the bank is really not worried on development. They are giving you a housing loan for your house. It is only staggered for the purpose of your benefit. Otherwise, the risk is yours.
And essentially, Gaurav, what you need to do here is actually get that agreement, read by a lawyer who will tell you if there are these clauses that Uday just pointed out, if these clauses are
Kavita, there is an important question I left to
Uday,
answer.
one second. The other thing that you also need to remember is if you do choose to not pay your EMIs. Now, the big problem that is going to happen, the big thing that will happen then is that it will impact your CIBIL score. And do remember that the developer has no, essentially there is no responsibility that the developer has towards the CIBIL score. You cannot turn around and tell tomorrow that the building was not constructed, the project was delayed, and so I stopped paying my EMIs. The fact is, it will be there, it will reflect in your CIBIL score, it will be a black mark on your score for the rest of your life and of your relationship with the bank, and you will find very difficult to get a loan after that. Uday, one other thing that
that's
Gaurav
a very
wants to
important
know.
point what you said,
Right.
because
Uday, one other thing that Gaurav wants to know here, he says that the agreement provides for an alternate property if the developer fails to deliver the property that has been agreed upon. Now, he wants to know how long does he need to wait before he can actually go to court and ask for that alternate property.
see, the status of the construction is very clear. If the builder has promised you the possession at XYZ time, and if he is not constructing and not getting completed, you can move immediately to consumer court, and there is a provision of interim relief for you, wherein you can ask for an alternate accommodation or even rent for that matter. If the agreement is providing alternate accommodation, builder must provide an alternate accommodation. Similar agreements are done in fact, in redevelopment, alternate accommodations are given or the rent is given. Here, you have every right to go to consumer court, get an interim relief immediately moved, and try and get an alternate accommodation which will be paid by the builder, or get an rent from him. But safer is to get an alternate accommodation, because if the builder stops paying rent, again you have gone to square one. So therefore, I would always suggest take an alternate accommodation from builder, buy an interim relief to the consumer court. Consumer court's interim relief not followed, he can go to the jail for 3 years.
Right. So Gaurav, 3 things that you need to remember. What you need to do immediately is move the consumer court and seek interim relief, and ask the court that it asks the developer to provide you with an alternative accommodation, which is anyway part of the agreement that you've signed. The other thing you need to do, get that agreement looked at, figure out what are your rights as per that agreement, especially with regards to the EMI that you're paying. And third, before you do that, unless you do that, do not stop paying your EMIs, because that will reflect on your CIBIL score. Moving on, we have an email query coming in. Alok Bharadwaj says that he's booked one flat through a dealer who promised to give him a discount of 3.5% of the basic price of the flat after 50% of the cost has been paid. Now, this commitment was not given in writing. Now, the dealer is not willing to honor that commitment that he made. What can Alok do?
The question that Alok has asked is, there is nothing in writing.
Sorry, I am just told that the commitment was given in writing. So, Alok does have written proof of the commitment.
Yes, if it is in writing, he can definitely go to a consumer court, file a case, ask for an interim relief like just now I said, and then interim relief, he can get that relief, because if it is given in writing. But if it is not given in writing, then it is very difficult. So therefore, if he says that it is in writing, where is this flat incidentally?
He doesn't say that.
All right, if it is not said also, anywhere in India there are consumer forums available. Up to 20 lakh he can go to a forum, about 20 lakh to 1 crore state commission of that state, or national commission in Delhi above 1 crore, and there is no limit. So if he moves the consumer court, I think that is more effective. He can also go to a civil court, ask for civil damages, get an interim relief in civil court. But generally civil court proceedings are long drawn, depending on the pendency. So what is advisable here is, consumer courts are much faster, and there is directly execution done through consumer courts, to the extent that builder can be inside the jail, or penalties, or attachment of the properties.
Can he also go to the police? Because here he clearly says that there was a commitment that was
you
given.
are right, Kavita, 100% on the dot. It is a cheating case, and he can go for a cheating case, lodge an FIR simultaneously along with the consumer court or civil court, which can go simultaneously, because criminal and civil are different, altogether different proceedings. They don't affect each other. So he can build a pressure by lodging an FIR. He can build a pressure by lodging a private criminal complaint in a criminal court and get an investigation order by a magistrate on the cheating and the other sections, and that avenue is also open to him. Of course, the effectivity, how fast the police will do the work, is another question.
So Alok, you have a number of options in fact that you can explore, and our suggestion is that explore all of them together. That will ensure that you put maximum pressure on the dealer concerned. For all you know, the dealer might just turn back and give you the discount that they promised without you actually, having to take legal action or fight it out in court. Facebook query next. Venkatraman writes in, says he bought a flat in the 1990s in Pune jointly with his son. Now, he bought the house from his earnings and added his son's name to it. However, his son unfortunately died in an accident and is survived by his wife and daughter. Now, Venkatraman is planning to sell that house. Can his daughter-in-law claim her share in the sale amount? They have nothing to do with this property. Should his son's wife give him a written document saying that she is not interested in the share? Are there any charges to be paid for the same?
Very good question. Most of the people may have this question. Here is a very typical thing. Though the house is bought by Mr. Venkatraman's money, the son is a joint owner. And now, being a joint owner, 50% share is of the son. And therefore, his share would transfer to his immediate legal heirs, and that is his wife and the children. Law protects the widows and the children. But in case, as he rightly puts in, there is a consent by the wife of the son, then she'll have to relinquish the rights, her part of the rights, make either a relinquishment deed very clearly, and it has to be registered, saying that she is relinquishing all rights to the father-in-law. If that is done, then there is no problem absolutely, and then I think he can easily sell the house. And NOC is also requisite. NOCs can be obtained from her also.
Okay, so essentially he needs to get an NOC from her, and then he can look forward to actually selling that flat.
But that NOC should be with a deed of relinquishment of the right, which should be registered.
Right. Moving on, question on Twitter next from Amit. Now, Amit tweets and says that a condominium is registered in his late father's names and he wants to delete his father's name now. What should he do?
See, condominium, there are unit holders, and the unit holders are the owners of their respective units. Now, if the father dies, he has to do the transmission of the condominium like we do in shares and debentures, and therefore he has to apply to the association which is registered for condominium and get his name transferred. Also, he has to get his name transferred in the conveyance, that is the deed of declaration. He can do that also. The amendment, he has to do additional deed of declaration by the developer if the developer is there, or to by the requisite authority, registration authority.
Okay. So that's the process that
and he'll have to take assistance of a property lawyer. I mean, it's not that easily done. This is a slightly complicated issue. So, therefore, I would definitely advise that take a local good property lawyer consultant who would help you out in drafting all this.
But Uday, before we move on, how does it work in a condominium? Now, in a society, we know that the nominee is not essentially the owner of the property. The nominee is just a trustee.
Correct.
What happens is, if you want to ensure that the property passes on to your heirs, you need to essentially make a will to ensure that they get their rightful share in the property. What happens in a condominium?
Will is always there, whether it is uniform and it is universal. If the will is there, naturally the will control everything. And in major cities like Bombay, Madras, Calcutta, you also have to probate the will and pay the probate and get the execution of the will done. But in the absence of the will, and very good question, Kavita, you are becoming more like a lawyer now. So, in the absence of the will, there will be many, suppose there are 3-4 children. Now, if only son is a nominee, as you rightly said, he will be a trustee of the property, not the owner. The society, the condominium can allow the transfer and give the NOCs, I mean the association of condominium, to the nominee as long as the other legal heirs do not object or he becomes a caretaker. But if he wants to own that flat, then he has to get deed of relinquishment done by the other, their NOCs will be also required, or gift deeds will have to be done, and gift deed is one of the best way of transfer of property between the legal heirs. The others can gift him the entire right, or as I said, they can relinquish, saying that for love and affection we are not going to claim the property and do a relinquishment deed and get it done. This is a normal procedure. It does not matter whether you are a registered society or you are a condominium. There is not much difference. The only difference is in a registered society you surrender the right to the society. The society is a real owner and have full rights of transfer. In a condominium you are a unit holder, like if you are owning a bungalow. Just consider for a moment that you are owning a bungalow, independent bungalow, and then your father is there, and suppose the father expires, then what do? you go and do proper transmission. You do a transfer in your name by either by a gift deed or by by surrendering the right of others. You register yourself as a legal heir to the property.
So essentially what you're saying is the rules
Stamp
are the
duty and
same, whether it is a
registration.
society
Exactly.
or a condominium, the rules are the same. A nominee is a trustee of the property, does not stand to inherit the property. If you want to ensure that a person inherits the property after your death, then make a will.
Unless is a joint holder of the unit.
Right. Or make
But
a will
even-
or gift it to that person.
But even if it's a joint holder of the unit, then the father's share would of course go to the others, no? So that is still coming.
Let's move on, Uday. We have an email query coming in now. Sanjeev Sood says that his father has been allotted a 1 BHK flat through the lottery system by Yamuna Expressway. Now, the payment has to be done in installments till possession, which is in 2021. His father does not want to continue with the payments. Instead, he wants to transfer the flat now in Sanjeev's name. And he wants the documentation of transfer to be done immediately. He doesn't want to wait till 2021. So what is the legal procedure for the same, as they only have an allotment letter in hand?
See here, Yamuna Express we'll have to see, because it is a lottery like MADA or in Delhi Development Authority.
Right.
They have their own rules of transfer. In certain cases, now take for example in case of SRA in Mumbai, you have a restriction that 10 years you can't transfer the flat. So he'll have to get it checked through a lawyer. Whether the Yamuna Express Highway, when the lottery was done, there was certain eligibility of the people to whom it should be given. Is there any embargo on the transfer? If there's an embargo for certain 5 years of transfer, then he'll have to get an power of attorney, irrevocable power of attorney by the father, and it will not be transferred. But if there is no embargo, he has to get the NOC of the authority first to get it transferred. And then he can register a proper transfer documents with the stamp duty registrar and get a property transferred by Transfer of Property Act. That can be done. But the point here is that he has to first check whether there are rules and regulations.
Embargo on the transfer.
That is
Basically,
very, very important in this, because these lotteries have certain criteria of allotment, also a criteria of transfer, and the transfer has to be noted to the authority concerned and NOCs of that authority is required.
right. Basically, what you need to check is whether there is a lock-in period. That's essentially what Uday means when he says embargo. Whether there is a lock-in, as in MADA in Maharashtra has a lock-in with lock-in of say 5 years or 10 years. You'll need to check if the Yamuna Expressway Development Authority also has a similar lock-in. Moving on, we have a website query coming in. Now, Nitin Soni says he lives in a society in Mumbai. Certain members of the society have not paid maintenance charges for many years. Now, the society has been issuing letters to these members for the last 5 years. The rest of the members are, however, paying the charges. What is a remedy for this? Additionally, the society is charging members who give their flat on leave and license an additional 700 rupees as donation for letting it out without staying in the flat. What can he do? Now, we know that there is a non-occupancy charge. What is a donation?
Donation is always illegal. They cannot ask. No donations except the transfer fees can be charged by the societies unless they are voluntary. I am underlying the word voluntary. Otherwise, such donations are absolutely ab initio illegal. But if there is a non-occupancy charged, that is allowed under the bylaws itself. So that query is solved, because your bylaws will define what are the non-occupancy charges for renting of the flat or even otherwise. So non-occupancy will have to be paid. His first question is about the outstanding dues not paid by others. He can raise a question in general body meeting. They can pass a resolution to take an action under section 101 of recovery if it is in Maharashtra, or otherwise also go for recovery suits, but it has to be filed by the society. Just because some individuals are not paying the maintenance, you can't say I will not pay the maintenance. You will be still a defaulter. You can even take an action of if at all the majority permits, after non-payment of dues and after due process of law is followed, for selling their flats by auction if the requisite authority helps you and you coordinate with them for that. So eviction is also possible after the requisite process of recovery is followed.
But you have to go to the registrar of societies after you move.
Yes, you will have to write to registrars of the society, and ultimately the society has to take the action. You as an individual cannot say others are not paying, I will not pay, and that won't be correct.
You should not become a defaulter. You should ensure that you are in the right when you are fighting for your own rights. Email query coming in. Sunil Ransube says that he booked a 2 BHK flat with a renowned builder in Pune in 2014. He has paid 20% as booking amount and the builder promised an agreement within 6 months and a handover of the flat before December 2016. However, agreement has not yet been done in spite of several reminders. He has also sent a notice to the builder and now the builder wants to make an agreement with his terms where there is no mention of the date of handover of the flat as well as no mention of the amenities promised, which was also there in the newspapers. Now, when Sunil asked the builder about this, he was told that the draft agreement is frozen and it can't be changed. There are over 700 other buyers who have signed the same, and if Sunil doesn't pay the remaining amount, then the builder will charge him 18% interest. If Sunil wants his money back, the builder will deduct 50,000 rupees and pay him back only after another person books the flat. What option is left for Sunil? You know, Uday, this sounds like one of those cases where the developer suddenly woken up and realized that property prices have gone up and I have sold my flat for a pittance, so let me try and get some more money out of the
Absolutely right, Kavita. It appears so that this is a total unfair trade practice, which is trying to do, by which he is trying to, squeeze the either more money from the buyer or take him out by cancellation and sell it to somebody else. It is not correct. He can rush to the consumer court. There is a violation straight away for not registering the. If he is purchased the flat in Maharashtra, MOFA would apply. Section 4 says that even if single rupee is taken, he has to enter an agreement, and otherwise also he can't take more than 20%. But here the consumer forum will come to a great help to him, because agreement is a liability of the builder to enter after he pays the money, and there has to be an agreement. Normally these terms of agreement are fixed by various state laws. Now RERA also has fixed standard agreement format. So these standard agreements are to be followed, and the other clauses which are unilaterally arbitrary, look at DLF case. Supreme Court has very heavily come on DLF, and crores of rupees are charged to DLF for unfair clauses in the agreement. So you can challenge even in Consumer Protection Act these unfair clauses of the agreement. There are several judgments of the National Commission. Most recent judgment was against, one of the question was against Lodha for making certain clauses which were against the MOFA. Similarly, they are against many builders, the judgments are there, but you must challenge these terms of agreement, insist on standard agreements which are very really fair, and the contractual obligations. Deducting money also seems to be unilaterally, unless it is a part of agreement which is agreed upon. 50,000 rupees deduction, that seems to be arbitrary unless otherwise provided in the agreement, and therefore it is better that he goes to consumer court and asks for his refund if the project is not getting ready, or if he wants to opt out after asking the possession to be completed in requisite time. Otherwise, it will become a monetary suit.
Now, you know, Uday,
Yes.
the problem here in
Yes.
Sunil's case is that he essentially doesn't have an agreement. He has paid 20% of the money.
True.
So what are the documents that he can actually showcase in the consumer court to build his case? Because over here, obviously, the first thing that he'll have to do before the court is to prove that he actually has some rights over that property in question.
Yes, because the day builder has issued him the receipt will say the flat number, the building in which he is going to get the flat, and it is sold for an house to be built by a builder.
Right.
And then builder becomes promoter, developer and service provider. Therefore, being a service provider, he should have entered an agreement is the first duty and obligation of the builder, which he has not done. There is a straight violation there. Then there is an unfair trade practice where the builder is asking extra money without any allotment letter or agreement or concluded contract, because the concluded contract then will go to the ready reckoner price of that time when he has booked it. The ready reckoner suppose is 2,000 rupees. Today you can't ask 5,000 and 6,000 rupees and balance payment. That would be a totally unfair trade practice, and there is a lot of wrongs done by the builder, for which a consumer can go to a consumer court for avoiding the unscrupulous exploitation by the builders, and that is the object of the act entirely. Therefore, it's a silver line to a common man, and therefore he, on the basis of receipts itself, he can prove that there was an agreement, that there was a contract between him and the builder. Builder is a service provider and he has defaulted by not entering an agreement, and thereby now it is an unfair trade practice to extract more money or making him go away or throw him away from his legitimate right of booking.
Right.
Because the rate can be found out from the ready reckoner at that time.
Right. So essentially, it boils down to this. It boils down to the fact that as a home buyer, you need to know your rights. And one of the biggest things that you need to remember is that if you've even paid 1 rupee, like Uday said, if you've paid even 1 rupee to the developer, you have every right to sign an agreement. You should demand, in fact, for an agreement. And if you do not get an agreement, that in itself should be a red flag, and you should either ask for your money back or take legal action at that stage itself. The other thing that you also need to remember is that once the developer has sold the flat to you, once you have signed an agreement, they cannot escalate the costs of that particular flat. It has been sold. If it has been sold at 5,000 rupees per square foot, that is what the developer is going to get. He cannot ask you for any more money after that. This is even though there is a cost escalation clauses which a lot of developers are putting in their agreements now. This, like Uday pointed out earlier, is an unfair trade practice, and you can go to court against it. And at the end, the other thing that home buyers need to remember is that you need to keep every scrap of paper that you get from the developer. You need to file it, whether it is a newspaper advertisement, whether it is a brochure, whether it is a receipt that you're signing. File it and keep it. It will stand you in good stead. Sure. That's it on today's episode of Property Hotline. Uday Wavikar, thank you very much for coming in, answering all those questions. And if you have any queries related to real estate, do get in touch with us. Do remember, this could be anything. It could be buying, selling, investing in property. It could be legal issues, issues related to property taxes, or issues related to home finance. We'll get the country's top experts to answer each and every one of them. Thank you very much for tuning in. Keep watching Magicbricks Now.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.